Welcome to Background Checks 101, FCRA Help Desk for Employers. Notice to users of consumer reports, obligations of users under the Fair Credit Reporting Act. Know your legal obligations. The purpose of this video is to present educational information about compliance with the federal law when employers obtain consumer reports from a background screening company. This is not a substitute for legal advice. This informational session addresses the U.S. Federal Fair Credit Reporting Act related to the procurement and use of consumer and investigative consumer reports. Legal requirements exist at the state and international level and/or regulated industries such as transportation, financial services, healthcare, but will not be covered in this session. End user's obligation. You must have a permissible purpose. Sign a user certification from your background check company. Provide disclosure to applicants. Obtain authorization from applicants. Give preliminary, adverse, and adverse action notices. Understand the remedying the effects of identity theft. Allow for the dispute of inaccurate information. Determine retention of records. Understand requirements of destruction of consumer reports. Permissible purpose. Employment is the permissible purpose for hiring, retention, and promotion. Under the FCRA, this is a legal purpose for obtaining a consumer report, also known as a background check. User certification. Employer certifies to the background check company. This comes in the form of a document your background screening provider that you, as the employer, have received the notice of user obligations, and that you have read, understand, and will comply with the legal obligations. Disclosure. Employer discloses in writing to the applicant employee that he or she may be the subject of a consumer report as part of the employment selection, promotion, or retention. This must be separate from the employment application. Authorization. Employer provides disclosure and obtains a signed authorization for preparation of the background report. This is an example of a disclosure and authorization form that meets FCRA requirements. There may be more state requirement notices that are not discussed in this session. Your screening provider may also provide this form. Preliminary adverse notice. When an employer is considering an adverse employment decision based in whole or in part on information in the background report, the employer must follow a two-step process. Step 1. Notify the applicant or employee with a pre-adverse action notice by mail, telephone, computer, or similar means. Provide a copy of a summary of rights under the Fair Credit Reporting Act. Provide a copy of the background report. Critical elements. The notification must contain that the adverse action may be taken based in whole or in part on a consumer report received from a consumer reporting agency, the name, address, and telephone number of the background check company that furnished the consumer report, including the toll-free number. Inform the applicant employee that the background screening company did not make the decision for the adverse notice and does not know why it was taken. Notify the applicant employee that they may, upon providing proper identification, request a free copy of their report. Applicant employee may dispute with the consumer reporting agency the accuracy and completeness of any information in a report. Allow the applicant to dispute the accuracy and/or completeness of the background report. The typical procedure is as follows. Applicant employee contacts the background screening company. Background screening company notifies the employer of a dispute. Background screening company reinvestigates any disputed items of information and issues an updated report of the reinvestigation to the employer and applicant employee. Employer reviews the updated report and makes the final employment decision. Adverse action. Step 2. When a final adverse decision has been made, a notice of adverse action is sent to the applicant employee. Wait 5 business days between sending the first and final notices. This is a sample of a pre-adverse notification that meets the required FCRA notification elements. This is a sample of a final adverse notification that meets the FCRA required elements. There are a few other important areas of compliance and good business practices, such as remedying the effects of identity theft. This document is prepared by the Federal Trade Commission and must be given to the applicant employee who believes they are the victim of identity theft. The applicant or employee should notify the Consumer Reporting Agency, and they should provide the applicant a copy of this document. The Fair and Accurate Credit Transaction Act is an amendment to the Fair Credit Reporting Act to prevent identity theft, improve resolution of consumer disputes, improve the accuracy of consumer records, make improvements in the use of and consumer access to credit information, and for other purposes, retention of records, and disposal of consumer information. The FCRA contains a 5-year statute of limitations. A law statute of limitations is the time frame during which a claimant, either the FTC or a job applicant or employee, is permitted to file a legal claim against USA Fact for an alleged violation of the FCRA relating to a background check. The 5-year FCRA statute of limitations starts to run on the date the alleged FCRA violation occurs. An FCRA violation typically occurs sometime between when a background check is ordered through several weeks, or more rarely, several months, after the background check is completed. The recommended record retention policy is 6 years for any record arising out of or relating to a background check, including, but not limited to, applicant's resume, employment application, disclosure and authorization form. Disposal of consumer information. Disposal of consumer information. To reduce the risk of consumer fraud, the Fair and Accurate Trade Transaction Act was signed into law, requiring any business to take reasonable measures to protect against unauthorized access to or use of the information in connection with its disposal. In order to provide additional guidance, the regulations also list examples of disposal measures that would be reasonable under the Act. Implementing and monitoring compliance with policies and procedures that require burning, pulverizing, or shredding of papers containing consumer information so the information cannot practically be read or reconstructed. Implementing and monitoring compliance with policies and procedures that require the destruction or erasure of electronic media containing consumer information so that the information cannot practically be read or reconstructed. This is the basics of compliance for employers who conduct background screening for hiring, retention, and promotion. Direct links to the full text of the Fair Credit Reporting Act, notice to users of consumer reports, remedying the effects of identity theft, and fair and accurate credit transaction. Thank you for viewing the Notice to Users video. Use this session as a building block for determination or review of your employment screening program.